All right, folks, it's the guy with the bow tie checking in with you live for another edition of Business with Benefits. To my right, we have a special guest for us today for a little earlier edition of the show. We have Natasha S.Lorraine Banks, employment lawyer, here to help us make sense of COVID-19 with employers and employees. So, Natasha, how you doing today?
I'm doing fabulous. How are you doing?
Good, just working on this quarantine life still.
Yeah, it's an adjustment,
Most definitely,
to
most
say the least.
definitely. Well, I'm going to check in with the audience real quick. If you're hashtag team live, put that and let us know where you are. Hashtag team replay, also let us know. We appreciate viewership however we get it. And Natasha, wanted to have you on because obviously a lot of states are reopening or kind of soft
Mhm.
reopening. So there's a lot of
Yes.
confusion around legalities of that. When this first happened, I was worried about what would happen with lawsuits with people, or could they sue employers, or can employees be sued, and things like that. So for the people that don't know who you are, kind of let them know who you are and why you're expert on this information.
Absolutely. So my name is Natasha Sarah Lorraine Banks. I'm an attorney here in Atlanta, and a fair bit of my practice involves employment law, where I advise my clients, which are employers, businesses, on a variety of employer-employee related issues. So that involves litigation, but like I said, it also encompasses advice and counsel on issues like what we're dealing with today,
Mm-hmm.
how to safely reopen your business in the face of COVID-19, how to deal with and respond to pandemics, what to do if an employee is uncomfortable with coming back to work, dot, dot, dot. So those are some of the things that I do. And I have done a number of videos in the recent months on my social media platforms advising on the new laws that have recently been enacted in response to the pandemic. So I appreciate you saying I'm an expert. I don't know if I don't know if I'm necessarily an expert, but I have read up and just been kind of thrown into the midst of all of these new laws and the rapidly changing legal landscape now that
Mm-hmm.
we're dealing with the pandemic.
Yeah, and the reason I say expert, I mean, I saw you on headline news, and I realized they only gave you a few
Yes.
minutes to talk about this. So,
Yes.
cable TV has a certain amount of time, but I said, man, we got to
Hmm.
talk about this more. And we
Hmm.
both had the Greek connection going on. I'm Kappa Alpha Psi, you're Alpha Kappa Alpha. We both
Yes,
know to
I am.
represent. So let's dig into this a little bit. So right now, as an employer,
Hmm.
Georgia is a great example. Georgia's reopened. So what
Yes.
are some issues that employers need to pay attention to so they're not caught with their pants down in some legal regard with COVID-19?
Well, employers definitely want to be educated about the Families First Coronavirus Response Act. That was the statute that I mainly talked about in my recent interview with Headline News. It was enacted on April 1st and it expires on December 31st. And it was enacted in response to employees needing to request time off for COVID-19 related reasons. And it applies to employers that have less than 500 employees, and
Okay.
it provides two different opportunities for employees to request time off if they are unable to come to work, whether it's working remotely or coming to the work site because of COVID-19 situations. So employers want to make sure they fully understand the parameters of these leave laws and what qualifies an employee to request and receive this time away from work. So the two different opportunities that an employee can request time for COVID-19 related reasons are either emergency paid sick leave or the Emergency Family and Medical Leave Expansion Act. So let's talk about emergency paid sick leave first.
Okay.
There are two reasons that an employee can request time under the emergency paid sick leave. It's if they need to care for themselves or
Mm-hmm.
care for another. And care for themselves, the examples are if an employee is subject to a shelter in place that's mandated by the government, or if the employee needs to seek a medical diagnosis because they're experiencing COVID-19 related symptoms, or they've tested positive for COVID-19, and at the advice of their healthcare provider, they have to self quarantine or self isolate. That is the self care reason that someone can request time off under emergency paid sick leave.
Okay.
Also, if an employee needs to care for another, if there is an individual in the employee's home that is subject to a shelter in place government mandated order, or at the direction of a healthcare provider must self-quarantine or self-isolate, and that prevents the employee from working remotely or going to work, that would qualify under care for others. And also, if there's a minor child in the home that is under the age of 18 whose school or daycare is closed because of COVID-19 related circumstances, the employee can request time off under the emergency paid sick leave for that reason as well. And that leave allots 2 weeks of time away from work, no more than 80 hours.
Okay.
And under the self-care reason, so if you yourself are subject to a shelter in place or your doctor has told you to self-quarantine or isolate, you can qualify for up to 2 weeks at no more than $511 per day. So they do cap how much you receive per day for that paid time.
Okay.
And if your reason is to care for someone in the home, whether it's someone who is subject to a government mandated order, healthcare provider directed them to stay home, or a minor child is there, that employee also can receive up to 2 weeks, but they cap it at $200 per day. So you receive 2/3 of your regular pay rate under that circumstance. And under the self-care, you receive 100% of your regular rate. But like I said, that's capped at $511, and care for others is capped at $200 per day.
Okay.
The other opportunity is under the Emergency Family and Medical Leave Expansion Act. Now, that allows an employee who's been working for you for at least 30 calendar days to receive an additional 10 weeks if the reason is to care for a minor child, and it's still capped at $200 per day, and the employee receives 2/3 of their regular pay rate. So
Okay.
employers need to understand that, and I know even with me explaining it now, people are probably real swirly listening to me explain all of that because it's a lot. And I mean, someone who's not a lawyer or in the legal field, or someone that does not have legal counsel, like I'm thinking of our small business owners who maybe can't afford to have in-house counsel or outsource legal work or get this type of advice and counsel. You really, really want to make sure you're familiar with these laws, because there are some legal implications if you don't follow the laws and comply with them. So it's a lot to take in, I know, but I'm hoping that helps explain what employers need to know going into reopening their businesses. Some employees may need to take time off. They may not feel comfortable coming back to work. And so that is one of the types of relief that employees are being provided.
Okay, perfect. We had the sound cut off for a second, but you're back. Well, I want to check with the
Okay,
audience
good.
real quick and dig into that. I put a comment up there. How do you feel about companies being prepared to return? Misha Berry, friend of mine, she said skittish.
Yeah.
And Emily Wells said many still are not taking precautions to protect themselves or others. We're not prepared for reopening. I say absolutely not. And it's very polarizing, this whole reopen thing. So when you broke down the funds that you were the $511 per day, the 2/3 of your pay, the employer is responsible for that, or the DOL?
So the employer is responsible for that. The Department of Labor, they are the agency that enforces these laws, that enforces these statutes, and oversees them. So the employee is responsible for paying that, but the employee does receive some tax benefits from complying with these statutes. Now, I'm not a benefits lawyer. I'm not even going to play like I am and break that down for you, but I do know that there are some tax benefits and tax relief that employers receive when they do provide these type of leave benefits to their employees.
Okay, and an interesting topic I came across recently was with this stimulus package, an extra $600 was added on to people's unemployment. So there's stories of people getting paid more than they were hourly getting because of the unemployment addition. So as an employer, this might not have been baked out all the way, but legally, they have they get the loan or the PPP money to help pay their employees when they're out, but they have to bring them back to work. So if the employee doesn't want to come back because they say, hey, unemployment's awesome, I'm making it rain all over the place with this extra money, what is the employer's kind of responsibility in that situation where the unemployment's more than they were paying them?
That's a good question. I mean, I think it's just a sticky situation that the employer is in. What I'm familiar with when it comes to unemployment, I mean, if an employee voluntarily resigns from their job, it's possible that they may not qualify for unemployment compensation. So if it's a situation where an employee, or let's say the employer knows that the employee has voluntarily resigned because they think that they'll get paid more with unemployment compensation than their employment compensation, then I believe that there may be a situation where the employee may not receive the unemployment.
Mm,
And there are a variety of criterias where an employee is approved for unemployment compensation benefits. And from what I understand, if it's a voluntary resignation situation, they may not qualify for unemployment compensation. But since the landscape has changed with the
yeah.
pandemic, I'm not 100% sure if
Mm,
that has changed. I don't believe it has, but that's definitely something that people have to think about. And I have heard that where some individuals feel, well, listen, I'll get paid more if I get unemployment than if I,
yep.
keep my job. But you know, people just they will have to make tough decisions, and employers definitely should be on the lookout for that and be aware that this is the mentality of some workers.
Okay, so far as the employer's, rights and everything, Georgia's listed out 20 or 30, I think, criteria you had to do to reopen as an employer. If the employer doesn't comply with those things and they have something happen as a result of COVID-19, far as an employee contracting it or in a customer, what's kind of their exposure for financial risk and litigation in that situation?
Well, one thing we have to understand is that COVID-19 litigation is going to happen. Actually, I take
Okay.
that back. It has already started happening.
Ah, okay, good.
We
I mean, good, not
we
good, but good to know.
it's not good at all, but we have seen cases being filed already. Employees claiming discrimination, employees claiming that they were infected at work. The
Mm,
issue is we're in the middle of a pandemic. So, for someone to prove that they were infected at one particular location might be a bit challenging. But
okay.
employers should do everything in their power to make sure that while reopening their businesses, they are complying with the Occupational Safety and Health Act. They are complying with the Center for Disease Control's guidelines and any state mandated guidelines, any local ordinances, any authority, legal authorities. You need to make sure that you are complying with that, legal and public health authorities. So for the guidelines that the governor set out, I mean, employers need to do everything in their power to make sure that they're following those guidelines because they were set in place to help mitigate COVID-19 liability and really to help keep their visitors and their employees safe and
Mm-hmm.
healthy. So it's really something that everyone's going to have to work very hard together to make sure that we're doing what we can to keep these businesses safe, keep these employees safe, so that we can
Mm-hmm.
safely reopen America and the businesses here.
Okay, so the employer has their set of issues they have to worry about. Now, the employee, let's say, like I have some daycare clients, some of the
Hmm.
teachers aren't comfortable coming back yet. So when the boss says, "Hey, we're reopen, come on back," what is an employee's rights in that situation?
I think the employee first needs to have an open conversation with their employer and
Okay.
ask them what type of measures are being set into place to ensure we are safe. And, as far as the daycare, the children are safe, or any workplace visitors are safe. Are we social distancing? Are we instituting staggered shifts, meaning less people are working so that we can social distance? Are we allowing less children to come and be a part of the daycare from day to day so that we can safely social distance the children? Are we disinfecting surfaces, encouraging, the rudimentary personal hygiene practices, washing hands, using hand sanitizer? I think the
Mm-hmm.
employee should definitely speak with their employer and find out what practices are being employed so that the worker can feel comfortable coming back to work. Now, there are some things that the Occupational Safety and Health Administration has outlined that requires employers to provide a safe and healthy work environment. There's the General Duty Clause, Section 5A1 of OSHA, which requires employers provide a safe and healthy workplace that is free of hazardous conditions that can cause physical harm or death, which obviously we all know COVID-19 can cause both of those.
Yeah.
And there's also Section 13 of the Occupational Safety and Health Act that states that if an employee feels like they are in fear of imminent danger, that they have the right to say, hey, I may not feel comfortable coming to work, or contacting their local OSHA agency to express their concerns. So there are some things that employees can do, but I
Okay.
really think that having open and honest conversations with your supervisor, with your employer, and working together to make sure that the facility safely reopen
Mm-hmm.
is the best bet. But I will say that employers should be very proactive.
Yeah.
Don't wait for your employee to tell you they feel uncomfortable. If you are about to reopen your business, you really need to put together a plan of how you will operate post quarantine. You need to put together a task force or a team of individuals that will be responsible for safely reopening your facilities and putting different measures in place to make sure that you're monitoring the pandemic, that you
Mm-hmm.
are, continuously updating policies and keeping the employees informed of the same. I would encourage employers to reach out to your employees before they come back to the work site. So as you are
Mm-hmm.
reopening, creating some sort of correspondence to send to your employees, explaining the things that you're doing to ensure that they are re-entering a safe environment. It really helps to just mitigate and lower stress, anxiety. It helps the employee feel more confident about coming back to work.
Yeah.
They really don't want to wait until an employee expresses these concerns or refuses to come back to work.
Okay, and I'd be curious for the audience if you guys feel like, or if your employer has communicated with you about the return, give me a curious reaction. So if your employer has actually reached out to you and talked about this ahead of time, throw the curious reaction. We had a comment from Randy. She said, "Team Live." Thanks, Randy, for jumping on. Emily Wells has a good question here. So she said, "What about the Uber and Lyft drivers who have leaded cars and could not afford to make payments because of that initial panic for the onset of the pandemic situation? Can they request unemployment benefits?" So Uber and Lyft drivers don't want people in their car. Can they get unemployment
Yeah.
based on this situation?
That's a very good question. I mean, I think the best legal answer is maybe.
Yeah.
It really depends. I don't know what state. I think her name is Emily. I'm not sure what state Emily is in, so it really depends on your state,
Mm-hmm.
and whether unemployment compensation would be provided under that type of circumstance. It really depends on your circumstance. You speaking with Uber, I believe with Uber drivers, they're independent contractors, but you have some sort of affiliation and communication with the Uber top dogs. So I
Mm-hmm.
would have that conversation with Uber and see if there are any things that they suggest that drivers do to make sure that they are safe. And it's completely understandable for an Uber driver or a Lyft driver to feel, you know what, I'm really not comfortable continuing on with this service.
Yeah.
I'm going to have to take a step back until things calm down. And you never know, if you talk with your employer, whether it's Lyft, Uber, or whomever, maybe there is something that can be put into place that, puts the employment on hold or allows employees to take some time with
Mm-hmm.
paid benefits, or maybe it's unpaid benefits, but they may be able to work out a plan to make sure that their drivers are safe. And even if their drivers need to take time away, that they have, some sort of relief if that is the situation. But I would tell her to speak with whoever her contact is at Uber and find out what type of options she has. I imagine she's not the only Uber or Lyft driver with
Oh,
those
she's not a driver. She's just
concerns.
asking, I guess, in general. She's here in Georgia, but she's just
Oh,
asking in
okay.
general.
That's a good
And
question. Thank you for asking. That's a great question.
And this is fluid, I think, too. So that's why it's good. You understand legalese and try to make it simple for people. So this is very fluid.
Yeah.
But Randy had a quick comment. She said updating policies is key.
Yes.
And I've seen this with some places. They just open back up and they just didn't tell people what the new process is. So let's talk about that side. If an employer reopens and the employee comes back and their scope of work has changed drastically, whereas maybe now they're cleaning 2 hours a day for desanitizing things. Is that something that can kind of push back on the employer, like, hey, this isn't what I got hired for, kind of a deal?
I think they will have to have good reason. If the employer is setting in place these new processes and protocols to ensure safety in a healthy work environment, I think the employee should collaborate as much as he or she can with the employer, even if it means that the scope of their job has changed, if it's
Okay.
for the greater good.
Yeah.
But if the employee is concerned, I think the employee should, really dig deep and figure out why they're concerned and how they can still meet the employer's needs, but have a fine balance between whatever concerns them and what their employer is requesting.
Okay. And the bridge usually between employee employer mostly is HR. So I'm sure a lot of them are dealing with these issues all the time. So for that, I mean, is the HR person the best person to help with this, or should a owner actually consult with the lawyer to say, hey, I need to have my ducks in a row here to make sure I'm gonna have a big, lawsuit or class action coming from my staff.
Mhm.
So should they seek counsel now to kind of be prepared for the return?
Absolutely and immediately. I would encourage employers to have counsel available to help them understand the ever changing legal landscape right now. I can imagine it will change even more as we continue to reopen businesses and deal with new issues that come as a result of the pandemic and us reopening. HR is a great resource. Don't get me wrong. I'm definitely not minimizing HR. HR is an excellent resource. I typically partner with a lot of HR personnel. So I would say the employer should work in concert with their HR department and legal counsel to make sure all their ducks are in a row. Because, like you said earlier, they don't want to be caught with their pants down and in a sticky situation that could have been avoided or could have been minimized and not bubbled up as much as it can if you do not seek counsel and work with your HR partners.
Okay. And that's where I think a lot of people are missing the boat is that, sometimes people say, well, I need a lawyer when a lawsuit happens or,
Hmm.
when something happens versus being proactive. So as this is changing all the time, you mentioned something about 2 weeks for the employees right now for the
Hmm.
Family First Coronavirus Response Act. Since it's been going on longer, I've had clients that have been hospitalized for 5 weeks. Um,
Hmm.
has there been any news or chatter about that changing, the being more than 2 weeks so far?
There hasn't been any news about that, but don't forget we still do have the original Family and Medical Leave Act, which allows an employee to take up to 12 weeks if they have a qualifying reason, and one of it is, a medical emergency of that sort. Now the FMLA, it is unpaid, but there are opportunities where if an employee has PTO, they may be able to receive pay under those circumstances. But that is something that an employee may want to look into, take advantage of if that ends up happening. And there's also short-term disability is also another benefit. There's the Americans with Disabilities Act as well, which also provides relief to employees that need a reasonable accommodation for any sort of reason where they're disabled and unable to perform major life functions, including working. And if you
Hmm.
are hospitalized for 5 weeks, that is definitely a circumstance where you are unable to perform a major life activity like going to work. So talk with your medical provider, talk with your HR department, and figure out a way that you can get that time off if you are in an emergency. And obviously, if you're in an emergency and you are hospitalized, you may not really be able to
Yeah.
communicate with your employer.
Right.
So have a family member get in contact with your employer in partnership with your medical provider, because employees will have to provide some sort of medical documentation. And in a
Yeah.
circumstance like that, it would not be difficult, for a doctor or hospital to write a note explaining the circumstance. And a family member maybe could provide that to the employer so that the employer's on notice if the employer was not aware when the individual was hospitalized. But that's a
Okay.
real question because, I mean, we don't know how long someone may be down or,
Yeah.
healing from COVID-19. So there are other options other than the Families First Coronavirus Response Act. So employees they really want to make sure that they speak with their HR department and their employers and supervisors to find out that information. And maybe
Mm-hmm.
employers want to provide a refresher to their employees about these different benefits and options if someone
Mm-hmm.
does fall ill. I think that's not a bad idea. That's something that will be very helpful for employees to understand as they come back to work. Like I said before, I think it's very important for employers to communicate their plan post quarantine with their employees before they come back to work. Drafting a memo, either mailing it to the employee's home or emailing it to the employee if the employee has access to email, and providing them these options that they have, providing them a list of how the employer is making sure that they are keeping the facility safe and healthy.
Mm-hmm.
And then when the employee comes back, don't just leave it at that one correspondence. Have a meeting, have
Yeah.
training, have periodical correspondence, whether it's an email or a periodical memo that goes out, a webinar explaining, how things have changed, signage in the workplace that serves as a constant reminder to employees of, hey, this is the new normal and these are the things we need to do, or these are the different options that we have if something happens and I can't come to work. So communicate, communicate, communicate.
I
That is
like that.
key. That is key. People have to talk to one another. And I know it's hard because everyone is just panicking, and very uncomfortable with what's going on. But I really truly believe we will get through this together. And when I say together, that's why I say we have to talk. We have to collaborate. We have to partner up and huddle up and figure
Mm-hmm.
out what can we do to make this a streamlined process of reopening our businesses, of meeting our employees' needs and meeting the business's needs.
I like that. I mean, that's where I think a lot of this is going wrong is collaboration on local level, federal level, state
Yes.
level. There's like a lot of not communicating happening right now, and I actually asked in the comments, has anybody known someone that contracted COVID-19? Because I seem to notice that the employers that are saying this is affecting 1% of the population, I'm not worried
Hmm.
about it. They haven't been touched by it. They kind of have a different mindset than someone that's actually lost somebody. And
Correct.
Randy was nice enough to share that she actually lost her brother to COVID-19 in April.
I'm
So
so sorry to hear that, Randy. Yeah.
yeah, and it's unfortunate the people of melanin are affected by this a lot more. It seems like with COVID-19. So what do you think is what to kind of bridge that gap? Because as an attorney, you have to kind of see both sides. Sometimes you're representing employers and employees, kind of different situations.
Yes.
So if employers have not been exposed to COVID-19, they just haven't had it happen in their family. They're kind of ranting and upset about this. What's kind of a financial thing or something you can point out to them to make them be more proactive about getting ahead of this thing?
It's very expensive to litigate a case. I would
Okay.
just say that. It's expensive. Even if you are in the right, even if an employee files a frivolous lawsuit, I mean, even the money that it would take to file a motion to dismiss or to file an answer or to conduct discovery, to file a motion for summary judgment, to do deposition, I mean, it's expensive. So you really want to avoid getting a lawsuit filed against you or getting an administrative charge filed against you with any sort of administrative agency, because the expense that it takes to defend the case is money you could be using to pour into your business and
Hmm.
increasing, your profitability. So employers need to know that when they're spending this money, it's taking away from their profitability. And it can
Yeah.
it can vary. I mean, it could be six figures, it could be less. I mean, it really depends on the issues, the employer, and the damages that the plaintiff is alleging. But
Hmm.
I mean, employers just don't even want to put themselves in that position. They
Yeah.
don't. And so I would say, really getting ahead of everything and being proactive and seeking out legal counsel, talking to your HR department, communicating with your employees. Not only that, documenting everything,
Hmm.
making sure you're keeping track and you're keeping record of all of these things that you're putting in place to maintain a safe and healthy workplace and complying with these new statutes or statutes that have already been in place. Any legal authorities, just having record and documentation of that really helps, because if litigation arises, you can present this document and say, no, we had constant training on this subject, and the training was in compliance with OSHA, or it was in compliance with another public health administrative agency or local ordinance or
Mm-hmm.
regulation. And you can show proof that you have done what you can to make sure that you're complying with the law. That helps. That it doesn't absolve things, but it does help. And employers definitely want to make sure that they are doing all that they can to keep track of their efforts.
That makes sense. I think the documenting part is probably a thing a lot of businesses are missing right now. And
Yeah.
that makes me think to an interesting point, because OSHA and workers' comp, and this is kind of tying insurance and law together, but OSHA and workers' comp are going to be kind of in the crosshairs for this thing, I think, because I know some states are talking about litigation for, will workers' comp cover COVID-19? Because you mentioned something about being a worry about being, passing away, a fatal endangerment. So have you seen anything yet that kind of says if, at least in Georgia, if workers' comp or OSHA guidelines can have a negative consequence as far as the workers' comp will cover COVID-19, or will OSHA guideline be breached if somebody gets COVID-19 at their job?
I haven't necessarily seen that, but I can imagine that that's an issue that will be discussed, and that will be addressed soon as more businesses reopen.
Okay. Yeah, and I figured that's going to be an issue just because, in California is a little bit more litigious than we are. That's where I saw a lot of it happening.
A little bit more? Did you say a little? A lot.
It's like a lot more
I
litigious
think I
than
misheard you. You said a little. I think you meant a lot.
I got to be. I don't know who's watching, so I got to be nice to everybody.
California
But
knows.
okay, gotcha.
It's
But
no
that's something
secret
to
to
worry
us.
about as an employer. I mean, because workers'
Yeah.
comp for like a roofing company is one of your biggest expenses. So if that becomes part of your workers' comp, I can imagine that being a cost
Okay.
concern. So for employers that have not
Yeah.
communicated, what's like a baseline? Let's say they're going to reopen next Monday. What are some key things you'd recommend employer have ready for Monday? That way, when they get back into the office, the business, the restaurant, whatever, they've covered all the bases. So they're starting that document trail. What's like the first step you think?
I think the first step is to, number one, try to correspond with your employees before they come there on Monday. I know today's
Mm,
Friday, but do your best. Maybe shoot them an email, give them a call, and let them know that what you've been doing in the meantime to keep the business safe and to disinfect the business. Number one, have you performed a deep cleaning? Did you do, sanitizing and disinfecting of the workplace? If so, let them know that. Let them know what new policies and practices um, you're establishing. So are you offering work from home policies now? I mean, we all have been working from home for
right.
weeks, so it's going to be a little difficult to employers to say, well, you can't work from home, because an employer's going to say, well, I really can, because I've been doing it since March. So maybe putting in place a work from home policy, outlining that policy and having that ready to go for the employee. And if the policy is not ready, because clearly today's Friday, have some talking points to express to the employees when they return on Monday. Let them know what's coming down the pipeline.
Mm-hmm.
Encouraging them to not share work equipment. Hey, if you have to share work equipment, here are some hand sanitizer wipes that you need to use to wipe down the tools or equipment. Once you complete use of those items. I'm encouraging employees not to share workspaces. If you have to share workspaces, making sure that you're disinfecting the surfaces and things of that sort.
Mm-hmm.
And really driving home, if an employee feels ill, it may be best not to come to work, especially if you feel like the illness is exhibiting symptoms similar to COVID-19.
Mm-hmm.
But employees need to communicate with their employer. They can't just not show up and not come for a couple of days. You have to let your employer know, give them reasonable notice, and accompany that with documentation from a healthcare provider. Because let's be real, if you're experiencing COVID-19 symptoms, you need to go to a doctor. You
Yeah.
do. So you need to have some sort of documentation to provide to your employee. So the employer needs to make sure that they sit down with their employees, talk about the steps they've taken to create a safe and healthy workplace. Talk about what policies are coming down the pipeline if they're creating new policies, and also discuss if an employee feels ill, they need to take these measures. Or if an
Mm-hmm.
employee suspects that another employee is exhibiting COVID-19 symptoms, this is the reporting procedure. This is who
Mm-hmm.
you need to talk to. Um, I would say those are the main things that employers need to be communicating with their employees upon their return. And just having some compassion. You
Yeah.
don't know who's lost in a loved one in the face of COVID-19. So just reassuring your staff that you are excited to have them back, that you all will work together to make sure that the facilities are a safe place, and discuss, all the new policies and procedures that either you have established or will be establishing, and maybe have a point person that the employee can talk to if they have questions, if they have concerns that surround the pandemic and this quarantine and the business, and how they can make sure that they're safe, and making sure they have that meeting, making sure they document the meeting, have employees sign a
Mm.
sign-in roster when they come into the meeting, and keep that documentation, and just make sure that they're staying in constant contact with their employees, and being open to talk, because employees may want to pull someone aside and say, hey, you know what, I'm experiencing this. What are my options? So maybe setting aside time during that first day that
Hmm.
employees can sit and speak with the point person about concerns or questions that they may have. So I know that was kind of a mashup,
No, no, that was good. I mean,
and
because
I
when
hope that was helpful.
no, that's good because when I said the Monday thing, I mean, a small business. Let's face it, they're a lot of them are the entrepreneur. They don't have the managerial side that
Yes.
strong in them. So it very well could be their opening Monday, and they're like, "Crap, I didn't do anything to get ready for this." And Randy earlier said, "Document, document, document," which I heard you reiterate that several times.
Amen. Yes.
So,
Amen.
so I love that, and especially the part about having that point person to communicate the symptoms, because I didn't even think about that. If somebody's feeling sick, I interviewed Deethra Giles a while ago, and she said in America we used to wear a badge of honor saying I've never missed a day of work in 5 years, in 10 years, and we all know you've been sick in 5 and 10 years. You just haven't told anybody. So everybody watching, when you're sick, stay
Right,
home.
right.
I hope you learned that lesson from this. If you're sick, just stay home and get better.
Especially if it's COVID-19 symptoms. Yes. Now,
Yes.
I'm not encouraging employees just to go rogue. I'm definitely not doing that. I want to be clear. If
Yeah.
it's COVID-19 related symptoms, if you suspect it's anything related to that, definitely you do not want to come to the workplace. That is hazardous.
Yeah.
And you want to go seek medical help immediately if you feel like that's occurring. Don't wait.
Yep. Well, Natasha, this has been great. You clarify a lot of things for the employer and the employee. You want to be mindful of your time, but I think you did a great job kind of laying it out.
Thank you. I'm so glad. Thank you so much for having me. I really appreciate it. And I appreciate everyone that had questions and comments. And I hope to come back again and provide more information.
Yeah, definitely. I wanted you to get more than 3 minutes. I love CNN and all that, but you need more than 3 minutes for this topic.
Yeah.
So for the people that need to find you and get more information about your practice, kind of let them know how to find you and what you specialize in.
Yes. So you can find me on Instagram. My Instagram handle is @attorney_NSLB. You can also follow me on LinkedIn. And you can also follow me on YouTube. My YouTube page is Natasha Sarah Lorraine. And so I hope you do follow me. I provide updates on a weekly basis. I have a variety of videos that I post that discuss businesses reopening and what employers need to know in the face of the post-quarantine life. And it's very helpful. It's been a great legal resource to a lot of people. So I want to invite you, yes, you that is watching this video right now, to be a part of it, and follow me for more updates.
Perfect. And we'll go back in the comments and put links and all that for you guys to easily find it.
I appreciate it.
Okay, well, Natasha, thank you. We had the Kappa connection going on today. So
Yes,
you be safe out there, and we'll catch you next time, folks.
you too. Take care.